Hello, friends and clients of Walker Gates Bella. I am Jennifer Walker Gates here today with my friend and colleague, Matthew Myers. Hey, Matthew.
Good morning.
Matthew has joined Walker Gates Bella of Counsel to provide our clients with employment-based immigration legal services. He is very experienced in working with businesses and individuals who are founding businesses to use that business to get, we're going to be specifically talking about investor visas, E-2 investor visas. These are really important for individuals who have capital that they want to invest and create a business in the United States. So that applies to a lot of people, and we're going to be talking about the basic requirements for those. Before we get into the substance of today's topic, please hit subscribe to our YouTube channel. We will be publishing these kinds of informative videos once a week and important updates for immigrants and their loved ones to have information that they need to obtain safe and permanent legal status in the United States. So please hit subscribe, and then let's get into it. Matthew, tell me about, in general, how the E-2 investor visa works.
Yeah, so there are really two temporary non-immigrant investor visas. One is that I consider the default is the L1 visa, but there are a lot of requirements for the L1. You've got to maintain a business outside the United States, which it's not good for entrepreneurs. It doesn't work for them. You've got to file with USCIS. It imposes a high level of scrutiny before we can go to the consulate and get a visa. And so the E-2 is available to citizens of certain countries that have a special treaty with the United States. E-2 Treaty Investor Visa Treaty. And what it requires is that a person from that country makes, or people from that country or a company from that country make a substantial investment in the United States, which is not marginal, meaning it creates one U.S. job is the most common way to show that, because it has to support more than just the investor, the entrepreneur, and his or her family. And it allows that person that starts the company or the business that starts the company in the United States to also bring over managers, executives, and essential skills employees from that same country. So there are a lot of well-known companies that started in the United States in that category. You know, Toyota has a plant here in San Antonio, and they likely use that visa category. BMW, you know, opened maybe 100 years ago and brought, you know, started with Germans and brought in the needed managers, executives, and special skills employees there. But I see it with restaurants, really every industry, tech companies, trucking companies, a wide range.
So you don't have to be a huge car company in order to get an E-2, right?
No. Most of the time, a lot of the time it's restaurants, and perhaps a lot of the restaurants that you didn't see closed during the pandemic may or may not have been E-2 investments, because in order to maintain the visa, they had to keep their business going.
So with an E-2, having a company established in the country of origin is not required. Is that right?
It's not required, and so there are some, for example, international graduates who have some family money and they want to open a business in the United States. And I talked to some that aren't from one of those countries with a treaty, and I have to say, okay, well, L1, you know, maybe your only option. Did you happen before you came here to work for a foreign company that's owned by the same or 51% the same people as the company you're going to start here, And they're like, of course not. I'm a college student, but it's a fun and good option uh, for people from those around 40 countries that have a special treaty with the United States to start up a
Okay.
business here.
So I want to back all the way up to the very beginning of what you were saying. And very quickly, just for those people who are watching who don't know, what's the difference? What is a non-immigrant visa and versus an immigrant visa? What is the difference between those things?
Yeah, so a lot of people know about, non-citizens who've never entered the United States, of course, and then permanent residents, green card holders, and then citizens. But a lot of what I do on the business and investor visa practice is non-immigrant temporary visas. And so they're approved typically in increments of 1 to 5 years. And it's a temporary visa. At the expiration of that 1 to 5 year period, we have to prove again that someone qualifies based on, whatever classification we apply under. So the E-2, for example, the person, foreign investor, entrepreneur, starts up the business in the United States, gets it going. We secure an E-2 visa, and then however many years later, we're applying again, showing that the business is ongoing, provide updated documentation and figures, proving that they still qualify, they still have the right to be in the United States or upon their application. So that's the difference there. It's temporary rather than permanent residency, where once you're a permanent resident, you renew your green card, kind of like a passport or a driver's license. It's not a substantive, significant application.
Okay, so for those non-immigrant visas, if somebody does want to become a permanent resident, how would they do that if they have an E-2 investor visa? Is there a way to do that?
There is. Sometimes we look at, if it's the investor, sometimes they do have, family businesses that they worked when they were abroad. And so they do qualify for L1 visa. And L1 allows for immigrant intent. So it makes the immigration process to permanent residency a little bit easier. But as well, you can go directly from E-2 to permanent residency. And some of the common ways, or the two common ways, are there's a category to pursue permanent residency called EB1C, which is for multinational managers and executives. And that's really limited to people that had and worked in businesses outside the United States before they came to the United States. And that process takes 1 to 2 years. And then a lot of people have heard about EB5. That's another common way to pursue permanent residency. But sometimes we can get creative, and there's a process called national interest waiver, where we say that the work is in the national interest of the United States, such that they should qualify for permanent residency or to apply for permanent residency. And so there's some other ways, but those are the most common ones.
Okay. And so you mentioned about 40 countries that have this treaty with the United States. What are some of the most common countries that you work with?
Mexico is the biggest right now due to the political situation there. Canada, the UK, Italy, Germany, Australia. Just kind of thinking through cases I've handled recently. Being in Texas, a very, very significant volume in Mexico, and just closely monitoring that. There are 2 consulates that we can apply in Mexico, and everyone is rushing to file in Mexico City, but now they're backlogged possibly a year or longer. And so the other place is Ciudad Juarez, where not a lot of people want to apply, but now they're processing cases in 3 to 4 weeks. So I'm trying to get the word out about that.
Yeah. So, so someone has what you call a substantial amount to invest, and what's the process like for applying for this visa?
Sure. And I want to be clear as well, because I've actually I've had this come up recently with Ukrainians. This visa is also available to managers, executives, or special skills employees of, to give an example, a Ukrainian-owned business that's 50% owned by Ukrainians, which could include the applicants. And so some people are getting creative with that to employ Ukrainians due to the current situation there. But the traditional process at the beginning of an E-2 case, someone coming to the United States, opening a business from scratch, they would incorporate, they'd open a bank account, transfer, the legal standard is substantial, which they don't give great guidance on. I would recommend at least $100,000, as a minimum, frankly, because we have to show it's enough to get a business started up and succeed long term. And you can eat up 100,000 pretty quick with any sort of payroll. So 100,000 transferred into a business bank account, and then that money, to a certain extent, starts getting spent on premises, inventory, equipment, and professional services, and all of that can be included as part of the investment. So maybe we have $50,000 still in the bank account, and then they've signed a lease somewhere which is allowed as a visitor. They've hired lawyers and accountants and other professionals, marketing people. Maybe they hired one U.S. worker, and so they've spent some of that money to start up the business.
Just to clarify, you're saying that the applicant will come into the United States typically and accomplish these things while on a visitor visa without even having their investor visa in place yet. They have to make the investment before they apply for the visa. Is that correct?
That's correct. And it's important to be careful with that part of the process. It's actually contemplated by the visitor rules. It mentions, you're allowed to come to the United States to review the possibility of investment. And it's commonly known that you can set up the business, but you can't work in the business. So you can sign the lease, sign contracts, do everything you need to do to get set up. But then when it's ready to start operating, you need to either have someone else be the operations manager, or you need to leave and apply for the visa. And so one of the requirements is that the business is real and operating, which is a catch-22 sometimes where you say, okay, well, he's not allowed to work yet, or she is not allowed to work yet. But we have to prove it's real and operating. And the standard for that in the first application is pretty low, as well as the marginality standard, proving that it supports more than just the investor. They require at least a business plan is maybe the most important part of the process. And we have to show at least a plan to hire a U.S. worker usually. Obviously, in a better case, it has to be
at least one U.S. worker that's not related to the applicant. Is that?
They can be related. We just have to show that it supports the legal standards. It supports more than just the E-2 investor and his or her family. And so the easiest way to do that is to show, the hiring of one U.S. worker, because it's supporting that person in addition to them. And so in the ideal case, at least 100,000, preferably hire one U.S. worker, perhaps to help get the business started up. So a lot of times I've seen a brother be involved. I've seen, a cousin or a close friend that goes into it 50-50 with the non-U.S. citizen.
And so
50%
when they say a worker that, or, benefits American workers besides the applicant and their family, they're really talking about immediate family that is not already a U.S. citizen. Is that basically correct?
Yes, it's like so there's the substantial investment requirement, which is left very vague. And I would say, a tech startup can be a lower level investment than like a manufacturing plant.
Yeah.
which requires a lot of machinery and equipment to really show you can operate. And then separate from that is this whole concept of marginality. And that's supporting more than the E-2 investor, his or her family. And it doesn't, I would say as a practical matter, a business plan showing projected hiring over a 5-year period, and preferably so that everyone can sleep at night, hiring or planning, having something worked out to hire a U.S. worker very quickly as part of the process.